Good afternoon and welcome to today's presentation, Litigating a Failure to Warn Claim in Product Liability on Personal Injury Cases. The information presented by the expert is not to be used as legal advice and does not indicate a working relationship with the experts. In today's webinar, Dr. Gerald Goldhaber will discuss legal versus practical definition of a warning, when a warning is needed, legal requirements of a warning, process of creating or evaluating a warning, samples of effective warnings and WACKY warnings, different perspectives on litigating a failure to warn claim. To give you a little background about our presenter, Dr. Gerald M. Goldhaber has been the nation's leading safety warnings and communications expert for more than 42 years. Dr. Goldhaber has been the subject of dozens of interviews by leading networks, newspapers, and magazines, and has designed warnings for dozens of consumer and industrial products. He is also the instructor of the official digital course of Warnings and Safety Communications for the National Association of Continuing Legal Education. Dr. Goldhaber has testified and consulted for lawyers presenting corporations or injured parties in over 1,000 lawsuits since 1978 and is currently CNN's chief analyst for issues dealing with warnings or safety communications. He's written 11 books, including this month's bestseller, Murder, Inc., How Unregulated Industry Kills or Injures Thousands of Americans Every Year, and What You Can Do About It. You can also find Gerry on his YouTube channel, Gerald Goldhaber, the Warnings Doctor, and his podcast, Warnings Doctor. Attendees who require a passcode today, the word is liability. During the Q&A session, we ask that you enter this passcode into the Q&A widget for CLE reporting purposes. The Q&A is located to the left of your screen. Please remember that if you are applying for CLE credit, you must log onto your computer as yourself and stay for the full 60 minutes. You are also required to complete the survey at the end of the program. Please note that CLE credit cannot be given to those watching together on a single computer. Dr. Goldhaber, the presentation is now turned over to you.
Thank you very much, Naja, and I want to give a personal welcome to each and every one of you. I understand we have approximately 300 people in the audience, and thanks to the work of TASA and Naja Edmondson here, I think that's an all-time record, I was told. Given the coronavirus situation, I hope that each and every one of you is staying safe and is staying healthy for you and your families, because that's a lot more important than anything else right now is our health. So I want to wish each and every one of you a safe journey through this and recognize one thing. We will get through it. We will get through it together. And remember, there's a we here and not a me, and we will all get through this together. I'd like to talk to you today about how you litigate a failure to warn claim in personal injury or product liability cases. If I could go to the next slide. I'm going to be, first of all, talking to you. You can skip the bio on me. You'll have plenty of time to read that. Naja's already told you what I'm going to get at, so let's go right to the first part about it, legal versus practical definition of a warning. First and foremost, we have to know what is a warning. Well, as I say here, a warning is a message. It's a form of communication, and it tells product users, consumers, about any danger that may be associated with the product or how you use a product. That's the key part. It's about a danger that you might be confronting when you buy or use any product. And in my book, I talk about the various settings where you would have this danger or these dangers, whether it's at home, at work, at play, traveling, communicating, whether you're residing at home or whether you're healing from a healthcare situation. Virtually every aspect of our lives, we confront product dangers. And that's really what a warning is. Now, at a practical level, if I can see the next slide, at a practical level, a warning is basically a form of communication that tells you about the danger And more than that, it tells you the consequences. So what if the third rail is electrified? What can happen to me? Well, that's open and obvious pretty much. The consequences are you can be electrocuted and die. So what are the consequences that can come from being exposed to the danger? And most importantly, and this is very relevant in today's COVID-19 arena, what can we do or not do to avoid these consequences? I want to take a side note and say one thing I've been saying in my podcast, The Warnings Doctor. I have never seen in my life a greater adherence to warnings than I have with the COVID-19. The literature shows us that about 20 to 30% people follow warnings depending on the sex of the person, depending on their experience, depending on how dangerous they think the situation is, and so on. This is over 92%, the polls are to be believed, that people are actually following what we call the instructions. The instructions are what we need to do or not do to avoid the consequences of the danger that is confronting us. Let's go to the next slide. So that's what a warning is. Now that I've told you what a warning is, the question comes up, when do you need to warn? Well, you need to warn, and this is a legal term, foreseeable versus unforeseeable. Foreseeable means that you, the manufacturer, would know, because you're in the best position to know, whether or not your product can be harmful to the user. There may be a danger that you can predict. Oftentimes, my clients will, if they're the corporations, and I work both sides for personal injury lawyers and defense lawyers, a corporation will sometimes say to me, Gerry, this is the best product since Swiss cheese. And I say, well, I'm not eating Swiss cheese these days, so we're not going to leave this room until you tell me how things can go wrong. What can happen? I was with my son, Mark, when we were on our way to visit the Nader Museum in Connecticut. We stopped at a diner, which is really a greasy spoon. And the only other person in there, by coincidence, happened to be one of the senior leaders of the IEEE, the largest trade group in the world, the International Electrical Engineers Association. And by coincidence, he was talking to me about a global initiative which they invited me to join, which is basically a very simple message to corporations. Before you market your product, would you mind taking a moment and go on pause and ask yourself, how can somebody get hurt by being exposed to this product? Before you actually manufacture and market the product, right after the design stage, can we pull a pause and ask the question, what can go wrong? And that's basically what I'm asking here. Do a pause. Ask yourself, what can go wrong? Let's go to the next slide, please. And the next question I have is, do you or don't you know about these dangers? Now, you're the manufacturer. You can go to the next slide. You're the one that should know more so than anybody else because you made the product. Now, the question now is, if you know it, does your user know it? A knife is sharp. I'll show you later on. My great staff found me a knife-like product that actually had a warning on it. But law schools have taught for years that the knife is the classic example of the open and obvious hazard for which a warning is not needed. Most of the time, however, the danger is not known or obvious to the product's user. Next slide, please. And so what we have now is called a hidden hazard. I boil it all down to two words. You need to warn when you have a hidden hazard. A hidden hazard is something you, the manufacturer, know about, but don't assume, next slide please, the consumer would know about. And that's a hidden hazard. Now, the question in courts of law, as an expert witness, we have to work within the court of law, and the courts have argued that the adequacy of a warning is determined by the judge or the jury, the fact finder. Now, we go to the next slide. Most courts tend to accept the following kinds of criteria. One is the danger or the hazard clearly communicated? In other words, is the hazard understandable by the user at the moment they buy or use the product? Next slide. This is very simple. I believe in fewest words possible. One of my sample warnings I'll show you in a few minutes is a diving warning that I designed for most pools around the United States. The hazard is very simple, 2 words, shallow water. So I have to communicate it clearly and efficiently. Next, we have to tell people what the consequences are. Now, sometimes people look at a warning and say, oh, just the stop sign, that's good enough. Well, anybody's got a ticket for going through a stop sign knows it's not good enough, because you need to tell people, and the research backs this up, that you need to tell people what the consequences are for being exposed to the hazard. What can happen to you? We see so many warnings in society that we really need to know what can really happen. With this coronavirus at the very beginning, a lot of people, I'm not being political here, but a lot of people said, oh, it's just like the flu. And they weren't really talking about the real consequences of a novel virus that could cause death to those, particularly with pre-existing conditions, who might get exposed. The flu may not do that, especially if you get a flu shot. So we now have to apply this to the products that we buy or use. If you know that it's shallow water, what can actually happen to you if you're exposed to that by, say, diving or falling into shallow water? So what are the consequences? And you have to tell people how they can get hurt, what specifically can happen to them, next slide, as a result of being exposed to the hazard. In the diving case, paralysis is the consequence. And I said earlier, a good warning has to tell you what to do or not do to avoid the consequences and to avoid exposure to the hazard. What do I need to do? I'm going to keep it within everybody's mind, the elephant in the room, I guess. You should shelter in place. That's why we have 300 people watching this or listening to it, because you're sheltering in place. And I guess I'm filling an hour for you today about what the user needs to do or not do to avoid the consequences. We call this the instructional component, and that's as important a part of the warning as knowing what the hazard is. Next slide, please. Now, the courts have said that a warning has to be visible. You have to, it doesn't matter if you have a warning on a product and nobody sees it because the print's too small. I had a client who put a warning on a product, but then they buried it. When the marketing people got a hold of the warning, they decided to put ads on the product, and ads competed for my real estate location for the warning, so my warning got buried with the ad. The warning has to be conspicuous. You can't play the game of hide and seek. I know that some people like to do hide and seek as a corporate strategy. That's not good enough. It's going to bite you, and it shouldn't have to happen. And by the way, I should back up. Putting a warning on a product is good for business. In my book, I actually did the research and found that there's $1.5 trillion spent on litigating products liability litigation every year. Products liability, personal injury litigation, with the cost of litigation and the cost of settlements exceeds $1.5 trillion annually. Now, that money could be put to a lot better use. Lawyers, you may not like what I'm about to say, but granted, it won't happen overnight. But if you take the amount of money that we're spending on litigation and just make our products better or make them safer, or we could take money and expand, pay our people more money, go into new areas of business. So it's good business to warn. And if you want to do your clients justice, make them see the light and put good warnings on their products. But we need to make sure that the warning isn't hidden. There's a lot of tools in our toolbox. We use bright colors. We have larger font and borders, large letters and boldface. We use pictures. By the way, pictures are important because somewhere between 35 and 45% of America is either functionally or totally illiterate. That statistic may be alarming, but it's actually true. If you take the low end, about a third of America is either functionally or totally illiterate. The difference is functional illiterate can read the words but not know what they mean. Totally illiterate can't read the words. And this is why pictograms are so important, so important. Signal words are very important as well. Now, I think my hypothesis as to why 92% of people, if the polls are accurate, are sheltering in place and following the instructions and to hopefully flatten the curve here. My research showed 30 years ago that the only signal word that actually had a meaningful difference was not caution, not warning, and not even danger in many cases. We had to get into lethal or deadly. And it's my hypothesis that because the coronavirus is perceived as so lethal and deadly and contagious, that people are paying attention. Next slide, please. Now, I've told you what a warning is. It's a safety message. It has basically a signal word, an instructional, a hazard, and a consequence statement in it, 4 components. It has to be conspicuously communicated to the audience so that they have a good chance of seeing it at the time of purchase or use. That's the basis of what a warning is, and you warn when the hazard is hidden. You warn. I had a client once who told me they wanted me to handle a bunch of cases. It had to do with motorcycle kickstands, and the kickstand was apparently not being brought up, and people were falling and getting injured. I didn't ride a motorcycle, but I asked the question, how hidden or open and obvious is this hazard? Well, one way to find out would have been to do a national survey of people who have motorcycles and find out if they're aware of this. Unfortunately, the client didn't want to do it. He just wanted me as an expert to assert that the audience wouldn't know and it would be a hidden hazard. I wasn't quite ready to take that on. So one thing we have to be sure about is that we have evidence that the hazard is hidden. Sometimes the open and obvious isn't so open and it isn't so obvious. I'm reminded, and I'll share with you what I wrote about the McDonald's hot coffee suit. I wasn't involved directly in that suit, but my company, which had among its divisions a market and opinion research division, we had a contract with McDonald's. And one of the things we did was a bunch of focus groups around the United States. And one of the things we found was people complained that the coffee wasn't hot enough. So McDonald's looked at our data and everybody and other people's data that they were collecting, and they decided to calculate the temperature they'd need for the average commute time from the time you pick the cup of coffee up to the time you get to work. Nationally, it was about 12.5 minutes. So they determined what temperature they'd have to make the coffee heated to get it at hot at when you got to work as it was when you bought it. And that turned out to be about 30 degrees hotter than the industry average. Ralph Nader has an excellent display in his Torts Museum in Connecticut where he explains this whole thing. The woman involved was Stella Liebig. She was an 82-year-old sweet grandmother whose grandson was driving through a drive-through at McDonald's in Albuquerque, New Mexico. Now, the comedians made a field day out of her being the poster girl for silly lawsuits, claiming everybody knows coffee's hot. And they said, grandson drove through, gunned it, and the coffee went flying. That didn't happen. The facts are that the grandson pulled over into the parking lot because Stella had a little shake in her hand and she wanted to put the cream and sugar in. And so he pulled over in the parking lot, shut the engine. The pickup truck was stationary when she spilled the coffee because her hand was shaking. Bottom line was, how hot is hot was the question. How hazardous was this product? If you ask the question, is coffee hot? Sure, people will say it's hot. If you look at McDonald's cup today, they still haven't put a warning on it. It just says caution hot. And by the way, about hide and seek, if you get that warning and you can see it, send me a note because I doubt it. I went over to McDonald's to look at it. It's yellow print on a white background, or white print on an orange background, light orange, orange, yellow. If I had to pick 2 colors that wouldn't match, those would be the ones. So it's absolutely hide and seek on just the words caution hot. But the question is the consequence clearly understood? And this comes to my theory of how hot is hot. Nobody knew that there were 700 Stella Liebigs before this one. That means 700. Nader's people told me there were 700 Stellas before this one, meaning 700 lawsuits before this one. But they all settled with an NDA. Lawyers, you know that. Non-disclosure agreement, and nobody knew about it, let alone the Consumer Product Safety Commission who's supposed to regulate it. So McDonald's goes on its merry way. Even to this day, they haven't put a warning on that their temperature is 30 degrees higher than the average. So when I say consequences, I want to be sure you understand what they are. So that's what a warning is. That's what the components of a warning are, and that's when you're supposed to warn. Well, second phase of this presentation is how do you actually create a warning? And then how do you evaluate it? It's a three-step process. Please, next slide. First step is basically to look at, and I'll get to the history of warnings in a second, is to look at the information about the product and its hazard. We need to find out whether we need to have a warning. Well, if you look at this slide, it basically says that whether you're considering the literature of warnings or the standards dealing with what you need to do to have a good warning, or federal regulations, or even the existence of warnings, it's basically a lot of it's happened in the last 30 to 40 years. Next slide, please. It's a relatively new phenomenon. So whether or not we're looking at the warnings literature, you can skip to the next one. You can see that this is all in the last 20, 30, 40 years, whether it's professional standards from organizations like ASTM or ANSI or the ISO, the International Standards Organization. Next slide, please. And whether you look at the actual federal regulations, there's, next slide, the CPSC or OSHA or NHTSA, you'll find that it's all happening, and even companies making product warnings. It just kind of exploded in the 80s and 90s. Next slide, please. So what are we doing? We're trying to figure out whether we need to warn. That's phase one. Do we need a warning? So there's a number of things I want to know before I can give you an answer. If you brought me into your room and said, Jerry, should I have a warning on a product? I got a phone call from somebody in Colorado a couple weeks ago. And he's got a product, I don't want to go into it because it's confidential, but his product may have a chemical in it that he's not sure if that chemical may cause cancer. So I'm doing some homework and we're finding out, we're doing a hazard analysis. And we're asking him and his marketing and his engineering, his design people, has he had any injuries? Has there a record of data? If you're dealing with a drug, there's what we call at the FDA, the AERs, adverse event reports. If it's the Consumer Product Safety Commission, they keep a record. NHTSA keeps a record. That's if people don't settle it or keep a non-disclosure agreement and don't report the data. Now, technically, you're supposed to report injuries. Not everybody does. I look for prior claims. I look to complaints. There's a lot of data I'm interested in, and if it's a clean slate and we don't know, then we don't know. Next slide, please. So one of the ingredients I'm looking for is to conduct a hazard analysis to determine what the hazard is and what is the evidence of the hazard. The next thing I look for is, I'm not proud, state of the art. Who are your competitors? When I was designing the warnings for, and this is public, for Owens Corning fiberglass wool insulation, having to do with inhalation hazards, exposure to the people who install fiberglass wool insulation for a living. This is not to you and me who maybe do it once or twice in our lives, but the person who does it every day does several a day. What is the hazard? It was something to do with inhaling the fiberglass wool particles. And one of my questions was, Owens Corning, who are your competitors? Well, it turned out Johns Manville, Certainty was another competitor. And I was very interested in what they warned about if they did. Well, they didn't. Turned out they didn't have any warnings. So I am interested in looking and see if a competitor has warnings, because we should definitely learn from what else is out there. What I want to make sure my clients have is the best warnings. I don't want to be out there in front of a court or in a deposition, have somebody hold up somebody else's warning and say that this warning was better than the one I designed. Next slide, please. So in addition to the competitor analysis and the hazard analysis, I want to know if the federal government or any standards organizations have had anything to say about warnings. Now, they may have plenty of standards about the design of the product, but I'm interested if the FDA or NHTSA or OSHA or the Consumer Product Safety Commission, now I consult for FDA, CPSC, and some of the other ones. I've done a lot of work with DOD over the years. So I'm pretty up on what regulations are, but I always like to double check, call my friends up in the agencies, and make sure that I know what the federal regulatory requirements are. I'm also a member of the ANSI, and I don't belong to any of their committees, and but I do get a lot of their literature. I'm now a member of the global initiative of the IEEE, which is 100 of their 50,000 members. And the goal of the global initiative is basically to tell manufacturers to put a pause before they market and sell their products until they figured out what the hazards are. Sounds pretty logical, but unfortunately it's not the case. There's some bad actors out there. I'm not naive. In my book, I write a lot about several of them, one being Takata. We all read about it. Their president and their engineers knew the hazard could occur about the airbags that could prematurely blow off shards of metal in particularly states in the United States or other places where there was high temperature and high humidity. And they basically buried the hazard until the engineers got religion and went to the New York Times. So that's pretty much well known now, but we need to be sure that the regulatory environment is working to tell us what to do. Unfortunately, I can't rely on the regulations because, as I point out, 2/3 of all regulatory commissioners since the creation of time have come from or went to the very companies they're supposed to regulate. This revolving door creates an inordinate conflict of interest. So as a warnings expert, I'll look to the regulatory environment, but it won't prohibit me. Most regulations are floors, not ceilings. So I will never tolerate an FDA regulation that doesn't go far enough. And in any deposition I've ever given, if a lawyer on the other side said, well, Dr. Goldhaber, we met the FDA. You can't deny it. And I'll say, yeah, you met the minimum, the floor, not the ceiling. There's very few exceptions to the rule, which involves a term called preemption. Tobacco being one, where because of congressional mandates, you can't go above or below the congressional warnings. But that's not the case for 95% or more of all products. You can easily exceed minimum regulatory or standard recommendations. Next slide, please. So as I'm gathering data about the hazard, I'm gathering data about competitors, I'm gathering data about regulations, and now I'm gathering data about who's your audience. In communication, we begin with who is the message intended to go to? Who's the audience? And I want to know, I had a pool client once years ago, and they were being sued by a person who became a quadriplegic for diving into shallow water. And it turned out that client, literally, even though the pools were 3.5 to 4 feet deep, they had on their letterhead, their sales and promotional letterhead, they had a logo showing someone actually diving into their pool. Not too cool. So we had to change all their marketing data. So it's very important that a warnings expert looks at the marketing information, the sales promotional, the brochures, and the internet today. It's very important. I was just involved in a settlement of a product, and I'm going to be talking about it in a few minutes. So I think I'll hold off on that because that involved looking at the marketing data and determining whether in the marketing data they're actually doing the warnings or hiding the warnings. So marketing information is very important. And it's also important as a warnings expert, you're writing basically a form of communication. It's a safety message, but you're communicating to a product user or a product maintainer, somebody who is buying or using or maintaining a product. You have to know who your audience is so that the message in the warning is appropriate, designed for the understandability of that audience. Because communication is measured as to its effectiveness by a very simple metric. The metric is, was the message received and understood? Received and understood. In my business, it's my job to get you into the showroom or get you to the water tank, but I can't make you drink it and I can't make you buy the car. So please don't judge me and my warnings by how many people followed them. I like to have them follow them, but I can't make them follow them. There's a whole bunch of academic disciplines that get between communication and behavior, like psychology, anthropology, and sociology. So my job is to make the best warnings I can and to make sure they're communicated as clearly and effectively as I can, and to hopefully people will understand them. You hold me accountable for whether my message is received and understood. You can't really hold any warnings accountable for whether people follow it, because there's a lot of things that get in between the cup and the lip. Many a slip betwixt the cup and the lip, my late father-in-law used to say. Go ahead, next slide, please. Now, The final thing I look at, and again, this is a three-phase process, the first phase of which I'm gathering data to determine the answer to the question, do we need a warning, or if we do, is the warnings you've got adequate? Are they adequate, or is it adequate? And the final piece of data I'll look at is, have you been sued? Have claims been made against you? And let me look and see what the warnings issues have been that have been brought against you. Because if you have, we need to fix it. So litigation analysis, along with regulatory, competitor, hazard analysis, these are kinds of data I need, next slide please, to answer the question, do we need a warning? Let's say the answer is yes, we do. Or let's say the answer is you did have warnings, but your warnings weren't adequate. Now it's phase two, I design the warning. I design it because I'm an expert in warnings and communication. I design it because I rely on the information I got when I conducted a hazard, a competitor, a regulatory, a market, a legal analysis, and I gathered all that data. That data informs my decision of what to warn about and whether to improve existing warnings. So I rely on all that information. I will design, I look at the codes, I look at the standards. Next slide. I look at the hazards. I want to make sure that I've covered the bases based on the data I've gotten. And then I design the warnings. Okay, that's good. How do I know if it's effective? I like to test them. If I'm designing a warning for a client, I test them. Now, if I'm brought into a case as an expert after the fact and I look at a warning, obviously I can't do post-remedial testing. If I'm going to change it, then I try to test it because, you know, in courts these days, experts like me and engineers are being asked not just to criticize, but we have to come up with alternative design. And so I will always come in with concepts in a deposition or a trial. At trials, I'll actually bring the samples with me as exhibits. Sometimes a depo, I'll have them prepared, but certainly by the time of my deposition, I'll be able to tell the other side what I intend to do at the trial in terms of alternative design. And if we have time, I'll try to test those warnings that I'm coming in with as alternative design. Testing is an extensive process. It's not a simple matter because you really have to determine that the audience involved received and understood the message. Remember the metric, effective communication, effective warnings, because a warning is just another form of communication. Effective communications are measured, are determined by the degree to which they are received and understood. Is the message received? Did the mail get delivered? Did the TV signal get on? Did the internet crash? Did you hear me today? Are you able to see my slide? Was the message received? And do you understand what I'm saying? Do you understand my words and my visuals? Am I getting through to you? Well, you'll have an opportunity. There's a measurement that TASA very nicely puts out afterwards where you'll get to evaluate and to determine, and I'll be able to know from reading 300 of your comments that whether or not you got the message today, whether you understood it. Well, this is what I do when I test warnings. I'll give you an example. We were designing there was a company from Japan that wanted to come into the commercial air conditioning business, Daikin, D-A-I-K-I-N. And their lawyers were working, the lawyer, and he brought me in because he'd heard about me, and I was, the other people from the company were all from Japan, so they all flew in from Tokyo, and we had like a United Nations meeting with translation, everything, with earphones in an auditorium, and I was trying to explain to them what the warnings would be about. So we got through and we put warnings on. Going through the hazard analysis steps, I determined that the only two ways you could get hurt or killed, or three ways by this product, was through electrocution, or you could lose a finger or a thumb, or you could get burned. There were three hazards. And the engineers showed me how this could happen. And so we designed some warnings, and it came time to test them. Well, I needed to test them on the right audience. Who was that audience? The people who install or maintain these large commercial air conditioning systems. Fortunately, there were showrooms around the country. They had one in New Jersey, one in Texas, another one out on the coast. So we went to all three of those places. We brought in about 100 people from each of those three locations. And these are actual people who install or maintain air conditioning systems, commercial air. And how do we bring them in? We had to pay them each $100 for their time. for an hour of their time. We worked with the unions and other sources to get people to voluntarily come in. And then when they came in, we had them fill out some preliminary questionnaires, and then we told them, hey, we've got some product here. Now remember, the key is if it's got to be received and understood, you don't want to tell them, go look at the warning. So you don't even tell them about that. We just say, we've got some air conditioning product here we'd like you to look at. Take a look and want your opinion. So they go out and they spend some time looking, and maybe 15 minutes or so. Then I call them back in, and we ask them questions about whether or not they saw different warnings and if they understood what the warnings were. And this is how we determine if something is visible, conspicuous, and understandable. Just one example. Have the next slide, please. So when I finish designing them, I test them. Now let me show you a few samples, and then we'll pause for some questions. This is mentioned before, a swimming pool warning. I designed it. It appears in most pools, I believe, around the country. It was accepted by the two leading pool organizations at the time. And notice it's very simple. I believe as a communication background, my background, that the communication of a warning should be efficient. That means using as few words as we can. We don't want to make up what I call a Mercedes-Benz warning that has too many words. I'll show you in a little bit one of those. So here we have a signal word. Remember, 4 things have to be in a warning. A signal word, in this case, it's danger. I put danger on because the hazard was immediate and life-threatening. If you dive into shallow water, it's an immediate risk to you that you could be rendered, as the nonverbal there shows you, quadriplegic. You could be paralyzed. What's the hazard? Shallow water. 2 words, shallow water. What's the consequence? You can be paralyzed. And the instructional component, what's the do or don't do? No diving. And the danger is in the ANSI recommended colors for danger, red and white, surrounded by a black border. And then I put a pictogram up that we tested and found out that 95% of the people understood what that meant. I put in the handicap thing. That was a little twist I put in myself. So that's an example of an effective warning. Next slide, please. Let me show you another one. This is one we did for a case we had in Texas. And again, we had to put it in Spanish. The only reason I'm putting this one up there is that I wanted you to see that depending on where your audience is, you should be ready to translate into the appropriate language. In southern Texas, in the Rio Valley where this took place, the majority language spoken was Spanish. So I would have been crazy not to put that warning in Spanish. Next slide, please. Now, this is one I had in a ladder case. You may laugh at this, and I did initially when the plaintiff's law firm called me up. I said, are you kidding? I'm not going to possibly be on the side of a personal injury lawyer dealing with a ladder. Well, it turned out that there was a real hazard that wasn't warned about very adequately. This warning I designed in both English and Spanish. Again, it was in Texas, in the Houston area. And the racking hazard was a hidden hazard. Nobody knew what racking meant. We tested people. Nobody knew. There were studies done, books published. Nobody knew what the hazard was. And yet it was the most common. I didn't know this at the beginning. I laughed at it. Are you kidding me? There's so many warnings on the ladder, no one will pay attention to it. It turns out warnings experts, we're in the real estate business. It's all about location, location, location. Turns out that on the step of the ladder, there's plenty of room. There's nothing on the steps. The warnings that are on the side of the ladder happen to be in small print, including one about racking, which is buried in the middle of a bunch of small print. Nobody had read it, seen it, and we tested it. We found out. We looked at 100 people looked at it. I think 3 noticed the racking warning that was on the current, we call that the control group. And then when I tested my warning, we had something like 80% notice the warning. Well, I put it on an empty step, the second step of a 3-step step ladder. Again, don't ask me to judge the stupidity or lack of the personal injury, the injured party, and why he fell off and how he got injured. That's not what I'm here to talk about. I'm here to talk about that there was a hidden hazard. The manufacturer knew about it. They put it in a warning, but they played hide and seek. And the rest of the public didn't know about it, and yet it was the most common hazard associated with falling off a ladder. So that got my attention, and that warranted putting a warning on a step where people saw it. And everybody saw it, and 80% understood it, 90%. So that's an example of an effective warning. Please go to the next slide. I designed these warnings for the Consumer Product Safety Commission and the 4 Japanese companies that made ATVs. There were a bunch of warnings I had to deal with, but the reason I put it up there was to show you that you can deal with people who are under 12. The risk to ATVs was a lot greater when younger kids were either stealing their father or uncle's ATV and going on it, or their parents were letting the kids go on it. And so the Consumer Product Safety Commission, for whom I've done a lot of work over the years, they asked me to come up with some warnings. I worked cooperatively with the industry because I was first hired by the industry, and then the government had their expert, but to save money, everybody decided, let's all get on the same page. We all want the same thing. So that warning, you can go to the next one. The reason I put it up there is to show you that we were trying to warn kids who were, preteen and teenage kids. This one is on the Ream water heater. The reason I put it on there was because this is an example of a warning for a product that nobody pays attention to. We do not interact with our water heaters. We buy it, stick it in the attic, the garage, or someplace out of sight, outside, hopefully, and we forget about it. Well, the problem is, until recently, the industry had a design defect in it. All the water heaters happen to have had something called a pilot light. In other words, the pilot light's what ignites the gas when you want hot water. It heats up the water. So that pilot light was located 4 or 6 inches from the floor. Well, I guess if you're storing your water heater in the garage, where a big majority of water heaters were stored, the water heaters actually, what else is stored in the garage? Well, your car, for one, cans of gasoline and other flammables. Well, guess what? And this is why it's a hidden hazard. Most people don't know that the fumes that come out of your gas cans and other flammable products you keep in the garage, those are heavier than air, and therefore they fall to the ground. When they fall to the ground, they creep along the ground, and guess what they're going to find? A pilot light that will light up those fumes and explode and cause a fire or damage and death. So we needed to put warnings on, and more importantly, we needed the industry to fix it. So this warning is really a stopgap measure. The industry did fix the hazard. Now the question is, should they keep the warning up there? My advice was, why not? Even though you claim you fixed it, if something goes wrong, at least you still got the warning up there. People aren't interacting enough with the product anyway. So next slide, please. All right, so we have warnings on products, and I'm a big fan of warnings. But I'm also a big fan of not warning when you don't have to warn. The earliest warnings, going back to the turn of the century, was a skull and bones. Literally, that was all we did in the way of warnings, mostly for what was the predecessor of the FDA, as the Food Act and Drug Act, and we had the skull and bones on a lot of products. I'm a big fan of warnings. I believe in warning for hidden hazards. I design warnings for hidden hazards. I've worked for over 100 of the 500 top companies in the United States, putting warnings on their products. Nobody's going to say Gerry Goldhaber doesn't want to warn about products that are dangerous. On the other hand, nobody's going to say that Gerry Goldhaber wants to warn about products that aren't dangerous. Next slide, please. Or you put on a warning that's for an open and obvious hazard. As you'll see here, this is what we've come to. Every year, I like to publish the silliest warnings that are out there. And these are warnings on products that are really, you really ask the question, seriously? This is the winner one year. A guy named Bob Arrigo, I believe his name, comes up with a group of the top silly warnings and gives out awards, and I kind of promote them in my newsletters and on my podcasts and sites because I think he's got a point. We do need to warn when we have a hidden hazard. We should not warn when we don't, because if you put too many silly warnings out, and this is really silly, warning, remove your child before folding the stroller. Really? If you can say really to something, then you know it shouldn't be there. Next slide, please. show you a few more. This is on, I was a Buffalo Bills fan for a number of years, and my home team. Read that warning. Decals are for decoration only and will not prevent you from bodily harm or injury. Really? Next slide. I sound like that comedian on Saturday Night Live. Really? Next slide. Warning, do not drink. Now, I happen to have Epson printers. I get ink cartridges. I'm kind of thirsty now. I've been going for what? 45 minutes. Next slide, please. All right, this is a catfish nuggets thing. It says contains fish like peanut. Next slide, please. So these are silly warnings. Let's stop after this one. This is my favorite one. This is one of those laser beam things from Star Trek, Star Wars. Blades are sharp. I'm sorry, wrong one. This is blades are sharp. My staff found this. This is an actual knife that has blade sharp. Next slide. When I said open and obvious, somebody actually, this is the laser beam. Don't be used as a battle device. Okay, let's go. Questions?
Okay, if all the attendees could please type in the passcode. Your first question is, I know we touched on the warnings in Spanish, but this question is there an evolving requirement for warnings in Spanish, for example?
The only requirements are strong recommendations that you take into account the audience for whom the warning is intended. It's pretty much an unregulated area, and pretty much you will get me immediately if I'm with any client. My statement will be, who's the audience? What languages do they speak? Now, this can get silly. Remember, you're not going to, you've seen an instructional booklet, how to maintain your television or something. It might have the instruction booklet in 14 languages. That's not what I'm talking about. Spanish is a no-brainer. I just had a lawsuit settle in Florida against Universal Studios. Disney and SeaWorld warned in Spanish. Universal did not. That was a no-brainer. I went to all three amusement parks one day, $100 each, by the way, and I found out that Disney World warned, SeaWorld warned in Spanish, but the Universal did not, and they settled the case very quickly. Next question.
Okay. After you make recommendations to your client, do you follow up in any way to see if it has adopted your suggestions? Would attorney-client privilege keep you from involvement?
Would attorney-client privilege keep you from what? What would attorney-client privilege
from involvement or commenting when the warnings you designed were not utilized?
No, if I'm on attorney-client privilege, I won't discuss it, obviously, with anybody. Any kind of, but I do follow up with all my clients. When you hire me to design your warnings, you got me for life, better or worse, till death us do part. And I mean that. I will constantly shop my clients' products. I mean, I designed the products on Playtex tampons for Tasha syndrome. To this day, I look like an idiot buying tampons. But I want to go and I want to check the warnings. The Dr. Pepper 7-Up and Orange Crush and all those soft drinks, the exploding bottle cap risk. I went out and bought them, and I would see if there was competition in advertising, and I would call them up and say, hey, you guys got to fix this. Now, the only leverage I have is if you are sued and they're going to ask the question, who designed this? And I'm going to get named out as a fact or expert witness, and I'll tell the truth. You know, that's not attorney-client privilege if I'm under oath, but I won't go around talking about my client's work because of confidentiality agreements, unless they give me permission to brag about it. They've done a good job. Playtex, I write about them. In my book, I feature my clients with their permission and knowledge. Next question.
Okay. Is a warning required on products such as Icy Hot to use only as suggested because they could cause injury?
Is a warning required on Icy Hot to use only as suggested? A warning is required if the Icy Hot instructions tell you the do's and don'ts, but neglect to tell you what the hazards are. You might find Gerry Goldhaber testifying against you. Because remember, the purpose of a warning is not an instruction. Instructional component is the do and don't, and it's only 1 out of 4 components in a warning. A warning has to have a signal word, a statement of the hazard, a statement of the consequences that can result, and the instructional component. Too often my clients think, well, look at the instructions, they're in the book. Do this, don't do that, do this, don't do that. Those aren't warnings, those are instructions. If you want to draw attention to a hazard, you have to do it the right way.
Okay.
Next question, please.
Yes. What does racking on a ladder mean?
Jumping the ladder.
Okay.
Moving it forward by jumping and not getting off. By the way, if I don't answer your questions today, I'm going to be sending a note to everybody, and you can write me, and I answer everybody's emails. I'm happy to, you can call me. I'm happy to talk to you. With the coronavirus, I got a lot of time. As a Bills fan, should of the warning. Oh my God! I think the warning should have been on Scott Norwood's right foot, and it was not. My son and I were at that game in Tampa, and it went right through. The referee was blind. 1991, New York Giants against the Buffalo Bills. Next question. Oh, I hate to see that. Next thing you're going to ask me if Bill Buckner, I'm a season ticket holder of the Red Sox, you're going to ask me if Bill Buckner should have had a warning on his glove not to fumble the ball. Oh, 1986, Mets, Red Sox. My son's listening, so this is for him. Next question.
What about the existence of safer designs that are available, similar to warnings on SUV visors about rollover risk versus passenger cars? In other words, should the SUV user be told about this risk?
Absolutely. Post-sale duty to warn. I'm in some cases now, I can't really talk too much about them, but the question is, did you inform people about the risks and the injury after the fact? Well, one case I'll be happy to talk to you about, I'm going to, in fact, let me take a few more questions, the Nap Nanny case, which is on the screen. That one, we went after the retailer because they failed to tell people about a CPSC recall. Toys R Us was the defendant in the settlement. Next question.
For manufacturers of, teratogenic chemical mixtures, is warning pregnant women should not handle this product sufficient when most women have no idea when they're pregnant?
Well, this is a technical question. First of all, I have no idea what the teratogenic chemical mixtures are. I'd have to study it. I'd have to look into the hazard analysis, and obviously the attorney involved here has got some litigation, and maybe from the framing of the question, maybe on the defense side, a defense argument, women don't know if they're pregnant. There are lots of warnings out there that pregnant women, in fact, I mentioned that amusement park, one of the key warnings in most amusement park rides that are risky, pregnant women should not be in the product. And I guess how hot is hot. But let me have that person who asked that question contact me after I've done some thinking before I can answer the question intelligently. Listen, I was noticing on the clock, if you want me to stop at 2, let me just, we can go to the questions.
Go ahead.
But let me go right to go to that next slide on, I want to talk about the 2 very quickly, just touch on how you litigate a personal injury warnings claim and how you litigate a defense, how you defend in a product liability case on a warnings case. All right, now you'll notice this is the Nap Nanny case. This is an infant recliner where a kid rolled off the Nap Nanny that was in the crib and suffocated when the head of the infant strangled by the crib bumper against the Nap Nanny, and the kid died. The warning was, if you can't see it too much on the left, but it's a Mercedes-Benz warning. Way too many words, too much on there, and the parents were 6 inches away. They saw it, but they just ignored it. They thought it was a message about how to maintain the product because they're on everything. There wasn't anything that grabbed their attention. So I designed a warning on the right side. First of all, I didn't use the word warning. I used the word danger. I would have gone to lethal or deadly, but I made it very clear. Your infant could die. That we tested, and people got their attention, and this case settled very favorably for the plaintiff's side. They should have had a warning that got your attention. The litigation of a personal injury case is there a hidden hazard. In this case, it was definitely hidden. You're putting the kid in a crib, and you don't know what can happen. Secondly, what is it that you're going to litigate? You're going to litigate that the warning was inadequate because the print was too small. The hazards, there were 3 hazards they tried to warn about in one warning. I focused on the most important thing. I said that there was a suffocation hazard, 2 words. They used 2 paragraphs. I said your infant could die. That gets your attention. And danger. This is right in front of your eyes. So the comparable was very compelling. If you're on a personal injury side and you're trying to attack an existing warning, those are some of the arguments I used. If you want to look at the flip side, go to the next slide. I'm defending on the Product Liability case, the shallow water pool. This is a warning that's on virtually every pool. If you go in and dive into a shallow pool, I guarantee you, if this sign is up, you're going to lose your case. You will lose your case. I have never lost a swimming pool case in 42 years when my warning was up. First of all, there's a question of there's been a number of summary judgments on standing in the depth of a shallow water pool of 3.5, 4 feet. If people are aware of the depth, many courts have thrown out on summary judgment the claims of the personal injury lawyer on the plaintiff's side. So most shallow water diving, if they've got my sign up, I definitely will not take the plaintiff's side on this. I'll be on the defense side because it's an adequate warning. Even though the hazard, it depends on the time of day too. If it's, most of these injuries occur by strangers who have never been in the pool before. So they're not aware of the depth of the pool. There may not even be depth markers. It might be a foggy night or a dark night. The lighting might be questionable. So the hazard could be hidden. If somebody's standing in the pool and there's 3 or 4 people standing in there, then that, of course, gives you the open and obvious defense. But at any rate, my warning is what gives me the opportunity to defend that case because it's an adequate warning. Okay, let's go back to your questions. The Napnanny case, by the way, Toys R Us was one of the named defendants along with the company that made the product. And they chose not to warn about the recall. And this person bought the product from a Toys R Us store, and they did not notify her and her husband about the recall. So that's a mistake retailers make. I've been involved in a lot of cases against Home Depot over the years where they are named co-defendant, because Home Depot is in the warnings business. As I said before about real estate, most companies are warnings, they're in the real estate business. Home Depot is selling shelf space, but they have a staff of people who actually engage on warnings. So if you're a personal injury lawyer, I definitely look to the retailer as a source of litigation, because big box retailers have to know they can't just simply put it on the shoulders of the manufacturer. They decide what products go on their shelves, and many of them have human factors people evaluating the warnings of the manufacturer. Okay, some more questions.
Sure. I will put it to the screen. And how do you handle cases where the message is mixed and therefore potentially confusing on the dangers of the potential hazard? For instance, where the company identifies the warning but also claims the product has a potential hazard, has a safety feature to prevent the hazard from manifesting?
Well, in this case, I would probably be working for the personal injury lawyer, not the defense lawyer, because the idea is to be as clear as you can about the nature of the hazard. The hazard has to be communicated. If you've guarded against it or designed the hazard out, then warnings almost become moot. The case of the warning of the water heater that I mentioned earlier, the hazard has been essentially designed out. The reason we agreed to keep the warning up there was that there was a 1 in 1,000 chance that the design feature could fail. So we decided to keep the warning up there. Not every company would have made that decision. But I will definitely, if the defense calls me in, I'm not going to go to court on this, but I will work with them to help them fix it behind the scenes. If they want to fix their warning, I'll say, hey, wait a minute, you got a mixed message here. We can't be confusing. By the way, quick question, Nadja, are we bound to the 60-minute rule, or if I want to stay a few more minutes?
We can stay a couple more minutes afterwards just to, respect everyone's time. So I'm going to give you 2 more questions.
Okay.
Okay. Okay, so this is the one. How do you overcome warning fatigue?
Well, that's the reason I said that Gerald Goldhaber will never shy away from warnings when they're needed, but he also won't shy away from telling a client, forget about it. I'm a New Yorker, right? Forget about it if the warning is contributing to information overload. Information overload occurs when you have warnings on products that aren't needed. And that's exactly why I am very interested in being very particular about it if the hazard is hidden. I do my part. I was once on 2020 and the announcer asked me that question as we were walking along and the interview was being conducted. They want to know, what do you want to tell the consumer? I said, don't be stupid. Pay attention to the warnings. In my book, Murder Incorporated, which you could get at murderinkbygerry.com, the podcast is The Warnings Doctor, and I'm on YouTube at Gerry on youtube.com. I talk a lot about what you, the consumer, can do. Last question.
Yes. Is there any industry standard for the physical size of a warning relative to the size of the product?
Yes, there are ANSI standards that, not so much about the size of the product, although real estate's important to me. I want to use the available space to the extent that I can. What I'm most interested in is the chart that ANSI provides. ANSI is the American National Standard Institute, and they have a Z535 warnings code that has 6 components. One of the components has a chart inside of it that has actually the distance that the average consumer is going to be and the size of the font that you should use. So if you have something that's 1/8 of an inch, you might be able to see it from about 3 feet away. So and so on. So you increase the size of the font to the distance that you want the warning to be visible. And if you've got a lot of space, I'm not simply going to say use all the space you've got. I want to be reasonable. So I want you to use as much space as you can so that the average user will be able to see the warning from the distance they're most likely to use it at. Great question. Thank you.
Thank you. And I was remiss. If you all could type in the passcode again, that'd be perfect. Thanks, Gerry, for answering those questions. And the overflow of questions that we do have, I am going to send them over to you, Gerry, along with the the stuff that I normally send you. Okay.
That's great. Now I just want to tell everybody out there, we're all in this together. Be safe out there and show a lot of love to everybody. That's what we need today. A lot of love and kindness. Be well and be safe, friends.
I want to take this opportunity to thank everyone for attending and most especially Gerry Goldhaber for his time and effort in creating this presentation. If you would like to speak with Gerry or if you would like to speak with a TASA representative regarding an expert witness for a case that you are currently working on, please contact TASA at 1-800-523-2319 and one of my colleagues will be following up with you regarding your feedback on today's presentation. Again, I will be sending out the webinar follow-up tomorrow morning, and I will be sending out the certificates. Again, they will be delayed as I'm one person trying to send everything out. So maybe by the middle of next week, you should have all of your CLE certificates. Thank you so much for attending, everyone. This concludes our presentation.